we would be covering, and what is the way forward, or what is the outlook on Prepack. There have been some amendments which have been proposed in January 2023. So, what are those amendments, and how does the scene look for the Prepack in India? Wait in the session. The way we'll conduct this session is somewhere midway through the session, we'll take a break of about 5-10 minutes and then resume with the session. So let me start with an introduction or genesis of Prepack. What was the need for having a Prepack in India? As you're all aware, 2016, we had this insolvency and bankruptcy code where a court-driven process was introduced for resolution of stress assets, which was earlier present in the form of only the SURFACE Act or the DRTs. So, but when the pandemic struck, a lot of MSMEs got impacted because of that. Their businesses faltered and they were driven into defaults and hence insolvency. However, these MSMEs have a very unique structure. Just to give a perspective, in terms of the numbers, MSMEs contribute to over 30% of the GDP of India, and a very sizable employment is what they create. So, in some sense, they are the backbone of the industry. So it was very important to safeguard the insolvencies of the MSMEs, and hence there was a thought of introduction of a prepackaged insolvency. Now, what is a prepackaged insolvency? It is essentially a hybrid system between a code-driven process and an informal process. So if you look at the code-driven process is currently our CIRP and Section 230 restructuring or scheme of arrangement under 230. If you look at the other end, which are the informal process or out-of-court settlement processes, which are restructuring under the June 7 circular RBI framework, or one-time settlements, or a bilateral restructuring. So this lies in terms of rigor, it lies somewhere in between. So what it tries to do, it tries to blend the benefits available in both these cases. In an out-of-court settlement, it is tailor-made process. Right? It does not have a one shoe fits all kind of approach. So that flexibility is very essential for MSMEs. And then, but to safeguard the interests of the creditors, so that this law is not misused or abused, there are inherent checks and balances present as are there in a CRP. Also, one of the I should have mentioned, the unique nature of MSME is that their businesses are smaller. Their organization structure or corporate structure is also very simple. Hence, to have the same, so it was thought to have an alternate mechanism which could facilitate a quicker resolution. The benefits envisaged earlier when the law came into force in April 2021 was that it will be quicker in terms of resolution, it will be less costly. So it would be a cost effective measure. It will help the MSME promoters who are genuine to be able to retain their companies under the restructuring route also. So these were the benefits envisaged, and with that, we have Prepack introduced in 2021 April. Prepack has been in existence in mature geographies for many years. The experience in these geographies has largely been very successful, but in some geographies, it has been a mixed bag. So just mentioning a trivia that in 2019, May 2019, a company in US, their Prepack was confirmed within 19 hours, setting a record as the fastest ever bankruptcy resolution case in the US. Different geographies have different nomenclatures like a Prepack insolvency, pre-arranged, scheme of settlement, etc. And their contours are also very different. It's good. Now let me cover the broad contours of a prepack. The major difference between a CRP and a prepack is that it is a debtor in possession model, or you can say it's a hybrid. In fact, it's a hybrid between debtor in possession and creditor in control. CRP is a creditor in control model, where here there is the management is with the promoters or the existing management during the initiation phase. However, there are checks and balances being exercised by the creditors. It is initiated by the corporate debtor. Unlike in CRP, which can be Section 7, Section 9, or Section 10, where the operational creditor, financial creditor, or the company itself can initiate. Here it is initiated by the corporate debtor, of course, with the consent of the financial creditors, with a 66% unrelated financial creditors with a 66% voting, and a special resolution by the shareholders, or in case of LLP, it is 3/4 majority. A base plan, there is a concept of a base plan which is available, or it is in the works even before the insolvency commencement. So there are two stages: the pre-initiation stage, which is the most important stage here. The plan is available on the date of initiation itself. The resolution professional, like in CRP, is approved by the financial creditors with a 66% voting, and he's appointed by the adjudicating authority. We discussed debtor in possession. Uh, since it is debtor in possession, the corporate debtor or the management runs the operations. So hence there is least disruption. The major challenge which was envisaged, or which we have seen in CRP in many of the cases, is that there is a disruption in the business. Immediately when the people or the world at large comes to know of the insolvency, there is a sort of unrest, or unrest among the suppliers, customers, employees. So all the business activities gets affected. Here, to prevent that, here the model here is that it's the management which runs the business. The insolvency resolution process cost has to be borne by the CD. Overall timelines in pre-pack are about 120 days. So that is for 90 days from the initiation date. Of course, we'll come to the overall timelines, how much time it should normally take. But 90 days timeline is for submission of the plan. So from the initiation date till the submission of the plan by the RP, it is 90 days. And then 30-day timeline is given to the NCLT for approval. Practically, this has not worked like has been the case with CRP and liquidation cases that we will see later when we see all the actual cases. 29A is applicable here with the MSME carve-outs which are there. The key thing here is that the promoter has the first right to make an offer and take back the company by offering a viable resolution plan. Of course, if he is eligible under Section 29A. If the committee of creditors does not agree with or is not satisfied with the plan offered by the promoter or the existing management, then they have a right to ask for a plan from external resolution applicants, and that there would be a competition if there are certain criteria which are there, under which there could be an open auction for above 48 hours, and the highest plan which is there will get precedence. So with this, I would I would ask Zina to take us through the detailed sections.
Thank you, sir. Good afternoon, everyone. Yeah, I think this is fine. Yeah, good afternoon, everyone. We'll be proceeding with the section-wise breakdown of VPAC. Before doing that, we'll touch upon some sections that precede the pre-pack sections, specifically Section 11A of IBC. Section 11A of IBC deals with a case where a pre-pack either precedes or succeeds a CIRP application. So, for instance, I'm audible, right?
Yes, ma'am. You
Okay,
have to
thank you.
increase your sound a little bit. I think either you have to come closer to the microphone. It is little weak.
Okay. Thank you, sir. Uh, is this better?
Not much improvement from the
Okay.
earlier.
Okay. Just give us a minute. This should be fine.
Yeah, okay.
Yeah, okay. Thank you. Thank you so much. So, a simultaneous prepack or a CIRP situation may arise if a CIRP application is filed first while a prepack application is pending. In that case, prepack would have to be decided first and then CIRP would be taken up. And if prepack application is filed during pendency of CIRP application, that is, a prepack is coming after CIRP has been filed, then two situations may arise. One, CIR prepack is filed within 14 days of filing CIRP application. That means that the gap between the two filings is 14 days. In that case, prepack will have to be decided first. However, in a case where prepack application is filed after 14 days of filing CIRP application, the CIRP application will be decided first. A common theme in this section is that prepack application will get precedence over CIRP application only and only if a CIRP application has been filed way earlier than 14 days. Only in that case, CIRP gets precedence. So the push towards making prepack the preferred mode of resolution was clear. Moving on. We now proceed to a process overview and a section-wise overview. So the process overview, we've divided the prepack into three stages. Stage one is what we like to call the zero period. This is where the timeline under prepack under IBC doesn't really get started. This is where the RP is in the role of an advisor, where all the required groundwork is laid out. The meetings are called of creditors, approvals are taken by creditors, board gives their approval, shareholders give their approval, declarations are filed, and the base resolution plan is prepared in this stage. And once all the ingredients are ready, a initiation application is filed along with the plan and the report of the RP with the NCLT. Upon filing, NCLT examines, and within 14 days, it is supposed to take a call on the prepack application. And once that is approved, in a 90-day period, the whole prepack process is supposed to be wrapped up. And it makes sense that the period is not as large as CIRP period because maximum amount of work is required to be completed prior to the initiation. Then comes the 30-day period in which NCLT will have to decide on the application filed for either termination or for approval of the plan received under CIRP, under prepack. So the role of IP in all the three stages is quite different. In stage 2 and stage 3, the role of IP is similar to that of what he plays during CIRP because he plays a very monitoring a role in which he oversight role, a role of an interim CEO, to be honest. And after the resolution plan, he will play the role of a monitoring professional. But in stage 1, his role is that of an advisor, and this is the stage where IPs may have a scope of upskilling themselves at this stage. Moving on, before we proceed with section-wise detail, we've split the sections, the major sections into two phases, pre-admission and post-admission. Section 54A to section 54O are the major sections that deal with prepack under IBC. 54A to 54C deal with pre-admission formalities, eligibilities, etc. And from 54D and C relate to admission and timelines. From 54E to 54O, we speak of the activities that are required to be conducted, how the plan needs to be selected, and if the plan is not successful, what will happen? And can it be converted into CIRP? All those questions get answered in these sections. We'll begin with section 54A, which deals with eligibility of a company to go under Prepack. Currently, as the law stands, it was introduced for MSMEs only. And the definition of MSME has also been given on the screen, where certain investment and turnover thresholds need to be met for a company to be classified as MSME. This means that the number of companies and the kind of exposures that are dealt with under Prepack are quite limited. And the minimum default amount is 10 lakhs. If these conditions are fulfilled, basic eligibility for filing of Prepack is done. Then we come to the requirements under the IBC before a company needs to file for Prepack. Just give me a moment.
May I interrupt? May I just ask a query?
Sir, we will have a Q&A session at the end.
That will become very boring if I to ask you.
Sure, sir. Go ahead.
You say that the minimum default is 10 lakhs, I know. Okay. Whereas in the other IBC, it is 1 crore. Okay. But the fact is that it can be initiated only by the CD. That makes it ineffective. What's your comment?
Sir, can you repeat that again, please?
The minimum default, as she said, is 10 lakhs in Prepack, right?
Right.
Whereas in the normal IBC, it is 1 CR.
Right.
Okay. But the fact is that the Prepack can be invoked only by the CD, makes it useless.
Sir, may I understand why you say that? Why does it make it useless to say?
Because
Of the
any creditor who is suffering a default have no option to file it under this. Because
sir, that is
unless it is 1 crore and above. Am I getting you?
Sir, that is right. I think the very intent of this Prepack is that the existing promoter or the existing management is able to run the organization and retain control while offering a resolution to the creditors. And hence, it is imperative, and like it is there with in most of the jurisdictions, that it be initiated by the corporate debtor himself. Having said that, there are enough checks and balances available that just when there is a 10 lakh default, it isn't that the CD can go and approach the courts on his own. He needs to have an approval of the shareholders. That is one anyways an internal thing. However, he also needs a 66% approval of the financial creditors. And sir,
Ashish, I agree.
there are shortcomings in the Prepack, which we will see later, and we will go into the reasons why it has not been as successful as it was envisaged. So the benefits which have been laid down, or the advantages which were envisaged earlier when the Prepack was introduced, despite those advantages, why it has not taken off in the manner that it should have. So we'll be covering that, sir.
Now, remember, when the IBC was first introduced, the threshold limit was 10 lakhs. Okay.
Right.
Then all those business people.
1 lakh, sir. 1 lakh at that time. Yeah.
It made it to 1 CR. Okay. So Prepack was pro CD, I know. But the very fact that it is excluding creditors' rights, or it is preventing creditors' rights, makes it unpopular and ineffective. That's the true fact of it.
I agree with that, sir. It has not been as effective as it should have been. I agree with that, sir.
This is to promote MSMEs. There is no liquidation in Prepack process. So,
sir, just to take on from what Mr. Matthew had
Anand Sonbhadra, if I'm allowed to speak, can I?
Sir, okay, sorry.
See, if I understand correctly, the whole purpose of bringing the Prepack was with an objective to give a pre-NPA or stress situation for the MSME to be able to take corrective action. This is a popular mechanism in the Western parts, or where the insolvency practice is there for, or law is there for more than 10, 12 years or 35 years. You'll find there this is the most prominent form which is used. Before actual stress happens and legal recourse start, this is an opportunity for the corporate debtor itself to take corrective action. So this is not for a reaction by creditors, in my understanding. And that's why, and this is only applicable today to only MSME. Hence, the level of default comparison to a crore is kept at 10 lakhs. And
My point is, yeah, I got your point. My point is, if it is going to be a proactive step even before the default, there is no point in having a default threshold defined. So why has the default threshold of 10 lakhs been defined when this entire process is going to be to preempt a default?
no, it is to preempt the insolvency or the bankruptcy process, which happens after quite some time after the default has taken place. Here, once default happens, an NP, you can do it within 6 months, within 3 months, it's up to you. Because till the time the default does not happen, no company would like to get into an arrangement of, insolvency resolution. Only when they're on the brink of a default or when they commit a default, they will go into it. That's the whole ambit of thought behind it, in my interpretation. I'm sorry, Ashish, you can kindly continue.
Yes, yes. Well, let us continue with this. So the intent is definitely a pro CD approach. MSMEs typically, and it has specifically been brought in for the MSMEs. MSMEs typically, when you try to sell, put them up for sale, you do not find many suitors. And if you put them under CRP, then there is all the possibility that it will go under liquidation. So to avoid that, this is a specific carve out or an alternate mechanism being brought, which has been brought in for the MSMEs. What we'll do, we'll go ahead with the section-wise coverage of the pre-pack. And then towards the end, we can also have some Q&A and deliberate more on the effectiveness, the purport, whether it has been actually achieved or not, and what are the challenges and what could probably be the amendments that actually should happen to make this pre-pack more effective in Indian jurisdiction. I would ask Zina to take this forward.
Thank you, sir. And that was a very engaging discussion. And we hope to get to it at the end of the session. We look forward to that. Great. So, we were speaking of the eligibility conditions, and in eligibility conditions, we were also talking about the ingredients required before a company can file for prepack. So these you would notice are very similar to the kind of conditions that are prescribed in voluntary liquidation as well, because the NCLT will have to ensure that the prepack is being initiated for legitimate reasons and it is not a ploy to defraud the creditors, which is why this requires a declaration from the directors stating that they will file the application within 90 days with NCLT. And there's also a special resolution passed by the shareholders or 3/4 of the partners if it's an LLP or partnership, approving the filing of prepack application. Apart from that, before a prepack application is filed, the company needs to call a meeting of the creditors and unrelated creditors. And in that meeting, by 66% majority, the creditors should also assent to filing of the prepack application. And along with that assent, they need to appoint the resolution professional as well. And with all these ingredients in place, assuming that the company has not gone under prepack or CIRP in 3 previous years before the date of the filing, they are eligible to file an application for initiation of prepack. And the most important ingredient is that there is a base resolution plan as well, which is submitted to the creditors before the initiation of prepack, and only if they find that viable. And on that base resolution plan as well, the RP is supposed to give a report, which will also go along with the prepack application. And when all of these things are ensured, that is when an application for prepack is complete. Now, on top of that, NCLT will also adjudicate. NCLT will also see if this is a legitimate application, and then the company goes under prepack. So getting a company from day 0 to day 1 of Prepack is a long process. And because there have not been many admissions so far, we do not know the extent of issues that may come up. Maybe once the scope of Prepack is broadened to cover more entities, that may also crop up. Moving on. Section 54B details the duties of resolution professional. The duties of the resolution professional start from date of approval of the resolution professional by the financial creditors, which will be any date prior to filing with the National Company Law Tribunal. And as mentioned before, he will be required to file a report. There is a format prescribed for the report on whether the company is eligible to avail of Prepack and whether the plan is as per the code. And basis that report, NCLT will finally adjudicate and admit the company in Prepack. During the preparatory groundwork that is needed, we believe that the RP may have to go through the financial projections, understand the existing assets and liability positions, understand the P&L, pipelines, order book, just to understand the feasibility and viability of the plan, the base plan that he is going to give a report on before NCLT. So we believe that this could be the preparatory groundwork needed. Understand the current cash flows, order books, asset position, understand sustainable, unsustainable debt to advise the creditors as well in the meetings. And thereafter, before plan submission, he also has to ensure that the plan meets all compliance and approval requirements under IBC, and that the information memorandum that is prepared before submission of the application is also up to code. Anything that gets placed before NCLT, before the initiation of Prepack, gets vetted by the resolution professional, except for the declarations and special resolutions passed by the shareholders. That would be a succinct way of putting this across. Moving forward, Section 54C covers the filing of the application and admission. And as per Section 54C, NCLT is required to admit or reject the application for Prepack within 14 days. In reality, we have checked this on the website, and this doesn't seem to be the case. And the date of admission will become the date of commencement of Prepack, or the equivalent of ICD. With the applications, the company is also required to declare that there are no avoidance transactions, or there are avoidance transactions, and these are the avoidance transactions. They're also required to give audited financial statements for last 2 years and provisionals till the date of declaration. So these documents are also required to be submitted. So to say, as on the date of taking a decision by NCLT, the NCLT is equipped with all the information relating to the company, its current status, and its future prospects. The timelines we had covered earlier is just a graphical representation of the 120 days. Day 1 to day 120 is split into 2 parts, 90 day of the actual process and 30 day with NCLT. And those 30 days as well in reality are not 30. They have actually gone up to 600 days as well in a case. Section 54E covers moratorium and public announcement. Now, moratorium under Prepack is imposed under Section 14 only, the section under which moratorium is imposed in CIRP. The same section, the same kind of moratorium is imposed, and it stays in place until the end of Prepack. And in case of public announcement, it is slightly different from CIRP public announcement. The form is different, but the mode of announcement is also different. It does not get published in newspapers like in case of CIRP. There is, you usually publish in one English language, one regional language newspaper. None of that in Prepack. You're just required to send it to all the creditors, upload it on the website of the corporate debtor, and upload it on the website of IBBI. However, in reality, we've seen that in 1 or 2 cases, the RPs have gone ahead and published the public announcement in newspapers as well. So that could be a question for deliberation at a later point in time. However, the Act or the regulations currently do not require it. Moving on, we want to cover the duties and powers of the RP under Prepack. They are very similar to CIRP with one important distinction. In CIRP, an RP is in charge of the company, the management vests with the RP, and the RP is whole and soul of the company. In Prepack, however, the board doesn't get suspended. The board is in action. The company is run by the corporate debtor. So the RP takes off a oversight role. So his duty is to monitor the management of affairs of the corporate debtor, but not to manage the affairs of the corporate debtor. Apart from that, the rest of claim collation, constitution of COC, preparation of IM, appointment of professionals, all of that is very similar to CIRP, including filing for avoidance applications. In powers, he can, one specific distinction is that he can attend the board meetings of the corporate debtor. So just another evidence to suggest that just because the board is allowed to function, it's really not allowed to function without supervision. That's why I think Mr. Rathi in the beginning called it a hybrid model, where it's actually debtor in possession but creditor in control in some way or the other. All the other protection that is available to RP under CIRP is available here. Like under section 19, he can still file for non-cooperation by the management, and he can still seek information from all financial institutions. This covers the major duties and powers of the RP. Then we move on to section 54G. Section 54G speaks of the earlier management handing over the preliminary information memorandum and a list of claims to the RP 2 days after initiation of the Prepack. Within 2 days, the earlier management is required to hand over a list of claims. There is a specific format specified for it and a preliminary IM. What this means is that all of this has to be ready before filing for Prepack application, because if you go by the ideal timelines, it should take NCLT 14 days to adjudicate on it, and within that, all of this information has to be ready. And a natural question here is the list of claims that is given to the RP by the creditors. How much can you rely on it? It is at the end of the day information that is originating from a defaulting entity. So there are safeguards built in the law for this. It says that if any person suffers any loss due to any omission or error in the list or the information memorandum given by the directors or promoters, then the directors, promoters, or whoever has authorized such submission will be held liable. And that person may also approach the court and litigate his matter. Then we come to one of the most critical pieces of legislation in Prepack, which is management of the corporate debtor. A major difference between the two is that the board is active and vested with the management in case of Prepack. However, multiple layers of safeguards are built to monitor the board. One, in the duties of RP, it is very clearly given that the RP is required to monitor the management by the board. Second, RP is empowered to sit in on the board meetings. Third, Section 28 of IBC is also applicable to Prepack proceedings. Now, just to refresh your memory, Section 28 of IBC says that lists a couple of actions that cannot be taken by the RP without COC approval. For example, appointment of statutory auditors, change in the management of the corporate debtor, raising of interim finance, alienating of assets, things that have a major impact cannot be taken without the COC approval. Now that is applicable in Prepack as well. What that means is the board cannot by resolution alienate any of the assets, raise any interim finance. So that's one layer of protection. The second layer of protection is under Regulation 50, Subregulation 2 of Prepack regulations. It allows COC to impose limits on the transactions that the company can do. For example, the COC can say that you will not transact a single transaction beyond 50 lakhs. And that curtails the corporate debtor from making any unwanted or scrupulous transactions. Second, the regulation also allows COC to impose any other restriction apart from those already covered in Section 28. So virtually anything and everything under the sun can be regulated by the COC if it wishes to. So this is a very powerful provision that emboldens the COC to take control back in their hands whenever they want to during the pre-pack process. So yes, the board is in control, but only until the COC wishes it to be. Also, over and above this, 50 subregulation 2 also requires the corporate debtor to submit monthly report on key developments to the COC on major litigations, on the status of operations, on assets, and any other matter that the COC may want to know. Over and above all of this, if the COC still feels that the management is being fraudulent or it's being mismanaged or there's foul play, they can vote by 66% majority that the management will now vest in the IRP, as in the case of CIRP. Then the IRP can file an application with NCLT, and after such filing, and if NCLT allows, then the management will vest with the IRP. And in that case, the board cannot be constituted, and it is like any other CIRP. So yes, it's debtor in possession, but with a lot of ifs and buts, enough to keep the corporate debtor in check. We must also bear in mind that this was supposed to be only for 90 days. The actual period of pre-pack was only envisaged to run for 90 days. Moving on, constitutional COC in pre-pack needs to be done within 7 days, and the first meeting needs to be held within 14 days. No, I'm just going to quickly brief on the technicalities. Notice needs to be issued with a 3-day notice. It can be shortened further to 24 hours with the resolution of COC. Second, quorum is 33%, and minutes need to be circulated within 24 hours. You may notice that the timelines in general for pre-pack have been shortened. In case of CIRP, this 24 hours is 48 hours. So it makes sense because 180 days has become 90. So it's natural that all timelines will be shorter. Second, in a case where there are no financial creditors and only operational creditors, or where there are no unrelated financial creditors, they may have FCs, but they could be related. In that case, the COC is formed by unrelated OCs only. And how that is done is you would take 10 of the OCs, the largest by value. And if there are less than 10, then you take whatever OC is available and you constitute a COC with them. And apart from that, you have one elected representative of the workman and one elected representative of employee. Very similar to SCC structure, stakeholder consultation committee structure, without the FC, of course, if I may draw a parallel. Then we come to appointment of valuers, preparation of IM, and filing of avoidance transactions. These are covered under Regulation 38 and 39, Regulation 40 and Regulation 41 respectively of pre-pack regulations. Within 3 days of initiation of pre-pack, valuers are required to be appointed by the RP. As in the case of CIRP, the valuers, there will be 2 valuers appointed, and the valuers will do a fair value and liquidation value determination. An average of the 2 estimates will be taken to determine the liquidation value. And like in the case of CIRP, this is only revealed to the COC after receipt of the plan and after obtaining confidentiality undertaking. So the value of the plan cannot be manipulated basis the valuation estimates. Information memorandum has to be given to COC within 14 days of a commencement. And this is also to be given after obtaining confidentiality undertaking. An IM under pre-pack is very similar to an IM under CIRP. There's not a lot of difference. The contents are pretty much identical. Then, but just to give a brief of the contents, it would contain the details of assets, of liabilities, of material litigations, of the constitution of the board, of the constitution of the management, of the conditions that led to the default, etc. Then we come to avoidance transactions. There are 3 stages to avoidance transaction filing. One is where opinion needs to be formed, second, where determination needs to be made, and third, where filing needs to be made with NCLT. For all the 3 stages, the timeline given is 30, 45, and 60. So on the 60th day from commencement, ideally, the application needs to be filed with NCLT. We've covered quite a good chunk of the section so far. So we're just going to very quickly summarize what we've covered. That once Prepack is initiated, a public announcement will have to be made in 2 days, and that public announcement has to be sent to every creditor and has to be uploaded on website. Then once claims are received, the claim will have to be collated in a particular form called Form P2, which will have to be sent to the COC along with the notice of the first meeting. And then the COC needs to be constituted 7 days from the initiation of Prepack, and the first COC meeting needs to be conducted within 14 days. And also on the 14th day, the COC will also get the information memorandum, and within 3 days, valuer needs to be appointed. And on the 60th day, avoidance needs to be filed. Apart from all this, the RP is responsible for day-to-day oversight of management of affairs of the company. Yeah. Now we begin with the most interesting part of Prepack, which is approval of plan by the COC. So as on the date of Prepack initiation, day 1, there is a plan available with the COC on the basis of which the Prepack was initiated in the first place, which is called the base plan. This is a plan that was submitted probably by the erstwhile management, and this was prima facie found to be okay by the COC. That is why they've initiated the Prepack to formalize the approval. However, so we'll call that step 1. Now, financial creditors can approve this base plan right away if it pays 100% to the operational creditors. However, if the base plan itself proposes any haircut to operational creditor, then the financial creditors are required to call for a plan from outside the company, and then they will have to take a call. However, even if the plan does not propose an impairment, the financial creditors still may choose to call somebody from outside the company. So as to say, the FCs are not bound by the base resolution plan after initiation. They can continue to explore value maximization opportunities. Then coming to so just on the OC bit, right? Because unlike a CIRP, where an OC, if it exceeds 10% of the overall debt, can become part of the COC, and it may not have voting rights, but it can at least participate or be witness to the proceedings. None of those rights are allowed in case of a Prepack. So cross-class cram-down is very, very possible. This is something, this has been introduced just to avoid such abuse. Then we go to step 2. If the COC does not want to go with the base plan, then it will throw the offer open to anyone outside the company. Of course, the invitation for resolution plan, or RFRP as we know it better in CIRP, is not to be published anywhere in any newspaper. However, you may invite it from investors. Currently, the law does not specify a timeline for submitting the plan. However, since it has to be completed within 90 days, we believe that the timeline has to be very, very competitive. It is 30 days in case of CIRP. So we believe anywhere between 15 to 20 days seems like a reasonable ask. However, that presents a complexity here because any investor who is completely alien to the company cannot be expected to have a proper due diligence done within 15-20 days. So possibly the suitors for this sort of a plan would be somebody who is in the know or who the company knows, or an investor that is willing to tie up with the existing promoter. So in step 2, after the COC calls for a plan, let's say it gets a new plan from outside the company. it can be approved by the COC if it is significantly better than the base plan. For example, let's say the base plan offered a value of 100 to the COC, and the new plan that has come is offering a value of 150. Now, the COC of company X may call that significantly better, but the COC of company Y may not call it significantly better, because significantly better is defined by the COC itself in IBC. So if it thinks it is significantly better, it can go ahead with the outside plan. However, if it thinks that the plan is not significantly better, let's say base plan offered 100 and the new plan offered 102, then the two plans will be pitched against each other in what could be an auction, and the plan with the highest score at the end of that auction wins the ticket. This auction is prescribed to run for 48 hours. And once auction completes, the highest plan emerges, then the COC will vote on that plan. Then finally, the application is filed with NCLT. The COC may still do not pick any plan, and in that case, Prepack will be terminated. A notable thing that even P ma'am mentioned at the beginning was that there is no concept of a liquidation in Prepack. You either come out of the Prepack victorious, or you just terminate the Prepack and go back to getting or evaluating other options. We've tried to summarize this decision making in our next slide. So the question to ask first is whether a plan other than the base plan is received. If no, then base plan is to be considered for approval. COC may approve it, not approve it, but it becomes a very straightforward decision making. But in case a base plan is received, the next question to be asked is it significantly better than the base resolution plan? If it is significantly better, then the COC may consider the other resolution plan. If it is not significantly better, then both the base plan and the other resolution plan get an opportunity to better each other until one plan emerges victorious. So this is a stepwise criteria that is currently set for evaluation. Also, in the auction that is done, as is the case in liquidation auctions, there is a certain amount proposed or a percentage proposed by which they can improve their offer in every bid. And this is called a tick size in Prepack. So the bidders can improve their offer by the tick size until the 48 hours elapse or one of the bidder withdraws. Under Prepack, currently the timeline says that 21 days from commencement, you're required to call for invitation for resolution plan. So which means that probably in the first couple of COCs only, the COC will have to take a call on whether or not the base plan is good enough, or if they want to call for a plan from outside. And the invitation for plan also is very similar to an RFRP. And it needs to detail what is significantly better, what is the tick size, how will the COC evaluate the plan, because in CIRP as well, evaluation matrix accompanies the RFRP. So there is complete transparency. Just to summarize what we have seen so far, plan is received by the company prior to the initiation of the process. And after receiving a plan, Prepack is started. All the activities that are done under CIRP are done under Prepack, with the exception that the management is still handled by the board of the company, the management of the company, but it can be taken over by the RP if needed. Then the base plan is considered for approval. If base plan is not good enough, COC can call for another resolution plan. And when that plan comes, COC needs to see, is this significantly better? If it is significantly better, they go for that plan and you file with NCLT. If it is not significantly better, COC may decide to have an auction between the base and the significant plan. And after whatever the way, they arrive at a final plan which has the highest score, which offers the best value. And when that happens, plan is filed with NCLT for approval. And within 30 days, NCLT is to approve the plan And after approval, the RP needs to intimate all creditors within 7 days of the order of such approval. Now, this is something that is not there in CIRP, and RP is not required to do this. But in Prepack, an RP is. And then the Prepack closes. Of course, this is the ideal scenario. Prepack can also close unsuccessfully, and we'll come to that in a moment. We'd just like to pause here from the section review and just take you through the safeguards that have been built in the pre-pack process. Because yes, the pre-pack process was rolled out for MSMEs, but it is not unimaginable that it will be extended further to become applicable for other classes of companies as well. So it has been introduced in a very holistic manner, keeping in view the overall objective of the code. One, we looked at the number of entry restrictions into Prepack. It is not possible to start a Prepack just by your own volition. You require the COC's approval. You need 66% of the creditors to say yes. Second, even within Prepack, avoidance transactions are determined. So if in the last 2 years something has gone down, something has not been done right, then that gets detected and avoidance is filed. So the creditors do not really lose out on their due recovery. Then, if the corporate debtor, if the financial creditors want to, they can also withdraw the Prepack, close the Prepack anytime before the closure of the Prepack and before the actual receipt of the plan. And that's a powerful tool for the financial creditors because they may not want to stick with the process once the process starts. Then the promoters are also required to be 29A compliant. Let's say there is a fraud with SEBI, there is a willful defaulter case, and there the promoter will have to cannot really come forward and submit a plan, and that is also a very powerful safeguard. Then the auction process that is there is a beautiful concept under Prepack because the financial creditors are not bound by the base resolution plan. They get to still explore value maximization in the market. They get to explore price discovery, and that makes it a very competitive process. And in the end, the plan has to still go through the rigor of IBC, has to go through vetting of RP, has to go through NCLC scrutiny. So it is more likely than not that the plan you end up with is a very solid, robust plan, way better than any OTS settlement that the bank would have otherwise reached in a case like this. There are a couple of more sections. For example, section 54L and M, they deal with approval of plan by NCLT. We covered earlier, the plan needs to be approved within 30 days. However, one important point to cover here is that if during the Prepack process, at any point in time, the vesting of the management has happened with the RP. That is, the board was suspended and court directed that the management will vest with RP due to malfeasance. Then the plan cannot say that the company is going to go back to the same management because that defeats the whole purpose of Prepack. In that case, the NCLT may order for liquidation. Then, like in the case of CIRP, you can appeal against an order of approval of plan for very specific causes which are listed out in section 61, contravention of law or irregularity in the process, foul play, very specific. But we all know that appeals can be filed for anything and everything. Then we come to how Prepack can be closed in section 54N. There are 4 ways it can close. One, plan is approved, successful outcome. That's the ideal scenario. Second, no plan has been received apart from the base resolution plan, or the plan received, whatever, the base plan or the other plan has been rejected. Then the outcome is unsuccessful, the Prepack will terminate. Then the COC itself may vote to terminate Prepack by 66%. That's a neutral outcome because the COC may want to, I'm so sorry, the COC may want to go ahead and explore other options. Then you may also want to initiate the CIRP by converting the prepack into CIRP. So that's also an option available, which is under 54O. So we're coming to it in a minute. So a prepack can be converted into CIRP, and from the date of conversion, it will be treated as CIRP. And if the FC does it, it's treated as a Section 7 application. In here also, it's a neutral outcome for the prepack. Section 54O. Anytime during the prepack in the 90-day period, the COC may decide, I want to go ahead and make this a CIRP. So it can do that by 66% majority. And in this case, NCLT again has 30 days to approve it. And the same RP who's working as an RP in prepack can be appointed for CIRP if he consents to act. Then avoidance applications which were filed during prepack continue during CIRP as well. And look back period will be from the date of initiation of prepack and not CIRP, which is very, very good, because it cannot be that that particular couple of months or whatever are just black days. They have to be counted in the look back period. Then prepack costs which have been incurred till that date will become CIRP costs. Another point to cover here is that in case liquidation is ordered, in that case, prepack costs incurred will become liquidation costs. So the law provides for treatment of prepack costs at all points. Unlike CIRP, where a lot of things have been left for the market to discover and determine and come up on its own, in prepack, because the time is very short, a lot of things have been templatized. Here, prepack prescribes from P1 to P14, a lot of forms, and from P1 to P8 are forms pertaining to pre-prepack period, and P9 to P14 pertain to post-admission. So for P1, I'll take very little time, but I want to cover from P1 to P14 very quickly. Form P1 is to capture the consent of the insolvency professional acting as the RP. Form P2 is for list of creditors that the company will give the insolvency professional. Form P3 is for approval of terms of appointment of the RP, which is again pre-initiation. Form P4 is for approval of initiating prepack. This is basically the actual consent that the creditors are giving, saying that I assent to initiation of prepack. Form P5 is the consent to act as authorized representative in case it is a real estate case. Form P6 is a declaration by the directors or partners, the declaration that we were speaking about, saying that we will file it within 90 days. Form P7 is the declaration regarding existence of avoidance transactions. So this again accompanies the application for prepack. Form P8 is the report by the RP, which will accompany the prepack application, saying that the company is eligible to avail prepack procedures and the company can do the things that is enumerated in the resolution plan. Form P9 is the public announcement. Form P10 is the list of claims, how they are to be collated. Form P11 is the invitation for resolution plan. Its cousin is the RFRP that we see in CIRP. Form P12 is compliance certificate that the RP issues to the COC and is filed regarding the resolution plan's compliance with all acts of the IBC, all provisions of IBC. P13 is an application for termination of prepack if the COC wishes to do that. And P14 is an application for vesting of management with the RP in case of any malfeasance. With this and with the permission of P ma'am, we would like to break for about 10 minutes, if that's okay, and then we can maybe resume.
Yes, ma'am. We can take a break.
Or if any questions so far on the content covered, we can maybe take it up and then break.
What is the experience so far? In the books, it is all okay, the 2 days, 3 days. What is actually happening?
So you're very prescient. You always ask the questions that we're about to just cover in the next slide. So, Ashish, sir, do you want to pick that up?
So we'll be covering this experience so far.
Okay.
And in the next slides, we have from the admission to the approval as against the prescribed timelines. As we mentioned earlier, the timelines have not been actually met or are nowhere closer to what was stipulated.
Yeah.
And the reasons remain the same, like the infrastructure issues at NCLT.
Yeah.
And also all those reasons remain same. Additionally, there is another reason in the PIRP that when it goes to NCLT, like is the case with voluntary liquidation, which is a procedural thing. Here, it is not viewed as a procedural thing because the NCLT will also apply its mind, and because it has been initiated by the CD, it is looked at with microscopic lens. So we will be covering that, sir, in the future slides.
Yes, sir. It should be looked with microscopic, but the fact is that we are not adhering the timelines. That makes it again another reason for failure of this much hyped IBC package.
Absolutely, sir, because the primary intent was speed and the ease with which the MSMEs can go in for a resolution. If the timelines are not adhered to, then it becomes like a vicious cycle. If there is no success, then there are very few additional cases going under this route. So as they say, nothing succeeds like success. Here, if there is no success, future also there will be a problem. So
Right.
with this, sir, we'll take a break of about 10 minutes and then come back and cover the rest of the sections.
Right.
Yeah, so the time now is 3:07, maybe 3:15 we'll reconvene. Thank you so much. Hello everyone, we'll just start in 2 minutes.
Yeah.
Hello everyone, should we start?
Yes, sir. Please continue.
Okay,
Yes, sir. Please.
thank you. So we have so far covered the genesis of Prepack and the section-wise coverage of the law and the regulations. Now let us look at, so this was the good part that we covered, which was the theory and the intent of law, how the advantages of having a pre-pack, the good part for the MSMEs and all that. Now let us come to the reality, how pre-pack has fared so far in India. So in the last about little over 2.5 years since Prepack has been there, these are the number of cases. So it's like actually you can count them on the fingertips. These are the cases which have actually been initiated. Some of them have been withdrawn and a couple of them are ongoing. So if you look at the number of cases which have been resolved so far, there are only about 5 cases resolved. Out of that, if we say the larger ones, Shri Rajasthan Sentex Limited, that had about 100 crores of debt, comprised of 3 financial creditors. This has been resolved. However, there is a challenge in NCLAT, which is ongoing. So we do not know the fate of this, whether it actually stands resolved or the resolution is struck down. Sudal Industries had a debt of about 150 crores, and that also had a few PSU lenders here. That has got resolved. So these seems to be the large ones. And Amrit India NT GCCL Infra was one of the first ones. So, as we can see on the screen, the days for admission uh, range from 45 days to which has even gone up to 628 days. Of course, let us keep that as an outlier. But even if you keep that out, the number of days for admission is too large. Uh, and similarly, for the delay. For the resolution also, the resolution timelines are also have exceeded a lot than what has been stipulated, 30 days from the filing date. So overall, there has been a delay in terms of the resolution, and the number of cases that have gotten into pre-pack are it's a very dismal record so far. So let us go into the reasons why there is so much delay. So the delay, first one is because of the infrastructure, NCLT infrastructure. That is a common theme across pre-pack, CRP liquidation. And there has been a lot of discussion, debate around that, and a lot of measures have also been taken in terms of increasing the number of benches, number of members. All those things have been done. The second reason for delay at NCLT is because whenever an application is filed, they will issue a notice. While that is not mandatory, as per the guidelines, the code and the regulations. However, because the courts function under just principle and they have to be fair to everyone, principle of natural justice which is there. Because of that, they will issue a notice, and that also leads to a delay in terms of admission. Also, it may be the case that there are dissenting creditors. 100% have not approved initiation of CRP or PRP, sorry. So in that case, they may have their objections. Also, as I mentioned, they look at because it has been initiated by the corporate debtor, and there have been a lot of instances earlier where there has been abuse of the process. Then every case is looked at with microscopic lens, and there is a detailed scrutiny. So I can think of these reasons which have contributed to a delay from a procedure point of view. Now, this is one part. Now, why the number of cases are just 6, 7, 8 cases have gone into, while if you look at the universe, there are a few lakh MSMEs. Out of that, few thousand MSMEs are distressed, and they are looking for a quicker resolution so that they can be back in business. But even they still there are a very few cases so far. So what is holding back is, are the MSMEs not initiating the that is one part probably, because and in a few instances or many instances probably they have been classified as willful defaulters, and they are not eligible to take this route of resolution. The other reason is that this is a sort of a voluntary haircut by the banks. The banks are not comfortable taking that call because every action of theirs will be scrutinized. So, because of this fact, there is a lot of reluctance on the part of the banks to initiate this process. While the safeguards have been built in that this has the approval of the NCLT, there is a statutory approval, there is a stamp of the court. So whatever decisions that they have taken will be protected, or they are protected against that. However, they are still not very comfortable initially saying that we are agreeable for a haircut. There could be instances where the operational creditor gets paid 100%, but the financial creditors have to take a haircut. That also becomes discomforting for them. That, and it is in variance with the section 53 as such, where you see that the financial creditors sit at the top of the waterfall mechanism and the operational creditors come next. So these are the broad reasons, I think, because of which Prepack in India has not progressed the way it should have progressed. Uh, I will take this up for discussion, and I would invite views of the audience on what can be done to make this better. What amendments? There have been some amendments which have been proposed. January 2023, the Ministry of Corporate Affairs had come up with a paper inviting for comments on the change of the insolvency law, and Prepack was one of the things there. And there were four amendments, broadly four amendments, which were put up. First one was to broaden the scope or to have a wider participation, not just restricted to MSMEs, but a larger number of other corporate debtors as well. This was the first one. The second one was right now there is a 66% voting requirement. 66% voting requirement, a lower threshold is proposed. 66% for agreeing to initiate the Prepack insolvency, and 66% voting for selection of resolution professional. That threshold is sought to be lowered. Another hurdle, what is being seen is that when the Prepack is being initiated, the board of directors, the management, they have to give a declaration that there are no avoidance transactions. Because of the structure of MSMEs, where there could be related parties, they operate in a smaller setup. There may be certain transactions which when the business is running its usual course may not seem suspect, but when the insolvency starts, they may seem suspect. And to asking the corporate debtor to give a declaration, a genuine corporate debtor may find it difficult and discouraging, and this might discourage them from initiating. Hence, it is proposed that to do away with this avoidance declaration. If we see section 10 application, where the corporate debtor files for insolvency under CRP, there is no requirement of having such a declaration. So it is being thought that you have a parity here. Another stumbling block or a bone of contention from the MSMEs is that the COC can take a call for change of management and then apply to the NCLT. Or if they find that the business is not run in a proper manner, there is malified intent, there is malfeasance or a fraud, then they can apply for CRP or liquidation, conversion basically of Prepack into that. Hence, so this may discourage so it is kind of giving all sweeping powers to the COC. Of course, there is a check that it goes to NCLT, but this may discourage the MSMEs. Hence, this also is sought to be amended, and these provisions are sought to be removed. This came in January 2023. So far, the amendments have not happened. Which way, whether all these amendments will happen or not, or there may be only few of them will actually happen, will depend upon the actual amendment which happens based on the comments that the ministry would have received. So I think with this we have broadly covered the piece on Prepack, and I would invite all the participants to share their perspective. Some of them would have been involved with the Prepack, and they would be able to give a first-hand view of how the creditors think, what is the view of how NCLT looks at a Prepack, or what is the view of the MSMEs. So I would request if anybody has any comments.
Excuse me, sir.
Yeah.
Sir, I have a query, not comment. Basically, I have a query. So, to judge this MSME criteria, MSME eligibility is important or MSME certificate is important?
Sir, MSME eligibility is important. However, the regulations also state that you should have MSME certificate also.
So, is it mentioned in the regulation, sir?
Yes, sir. We will share that separately with you, sir. It's mentioned.
Sure, sir. Thank you so much, sir.
Sir, any other queries or any comments? So, P, we may conclude the session then, and from our side, we'll be sharing across the presentation
Okay, so
with you,
you
and
are
then you
done
can
with
onward.
your presentation now, sir?
We will share it with you, and then you can share it with the participants.
Okay, okay, sir, no issue. And last time I'm requesting participant if they want to make it interactive session, so they can ask any question related to today's topic.
So while we threw it open to discussions, Ashish sir has done it over the course of the thing as well, and even just now. And we did have a query. I somehow get a feeling that you were probably not connected in the last couple of minutes. And yeah, and I mean, yes, if there are any queries, we'll be happy to have a good interactive Q&A.
Okay. Can I ask one query if no one is asking? So I just have one query that about applicability or utilizing this section 54O, whether if default of MSME is less than 1 crore, then also can this section 54O can be used by that MSME for converting PPIRP to CIRP process.
Just give us a moment. Yeah. So that's a very good question, first of all. Very good query, because when we were discussing as well, this came to our mind that it seems like a backdoor entry for CIRP, where you're not meeting the CIRP threshold of 1 CR. You rather put it in pre-pack and then you convert into CIRP. Then you completely bypass the requirement of CIRP of 1 CR. So it seems to be that way, but I would say that because it goes to NCLT and it is deemed as a Section 7 application if it's initiated by financial creditors, it comes down to NCLT adjudicating the matter. And I would tend to believe that NCLT would not admit a company under CIRP which doesn't meet the debt threshold. That seems to be the reading as of now. But if something like that comes up, that'll be very interesting. It would probably be an abuse of this section.
Yeah.
So does that answer your query or?
Yes, ma'am. This was all
Yeah,
my
thank you.
query. Thank you.
Ashish, I want to ask a question.
Sure, sir.
Okay, this is a little, maybe you think it is little hypothetical. In my view, I'm a banker. In my view, the stress in the MSME is very high, although in terms of amount, it is low. Okay.
Okay.
So because of the fact that the size per se is low, but the fact is that the government wanted a very pro CD risk IBC mechanism. That's why designed the Prepack. Okay, fair enough. But I would say that it would have been better. Okay, I don't know how far, how many people agree with me that we have taken it without NCLT business. Because once we taken into NCLT, the whole thing gets into a legal tangle. We leave it to the CD and the FCs or the committee COC. Would it not have been better?
Sir, you are right. In certain geographies, that is the case, that there is no involvement of the judiciary in this. But given the peculiarities in our country and the way we operate, uh, also there are several parties, right? Because there will be an operational creditor who is also there in the scheme of things. In that case, a COC taking a decision on the prepack would also be subject to challenge on the grounds of natural justice. Whether it goes to NCLT for approval or not, there would be other forums where they can get challenged. So I think to reduce the litigation piece, it has been proposed that it goes through the NCLT route. And sir, I believe that once the infrastructure issues are fixed, and when there are more cases under this route, there would be better learning for all the stakeholders, including the judiciary, and they would be able to appreciate this much better. Maybe there will be a scenario where we have an avoidance transaction audit done beforehand, a forensic done beforehand. All these things will, and then practically that would come into picture once there are more cases. But at the current juncture, sir, I think without right now, even when there is NCLT cover or a shelter, lenders or the bankers are very wary of taking a decision or initiating under this route. Without NCLT blessing, I am not sure whether there would be even a single case. So my view is that, sir, as of now, NCLT structure is a must, and maybe a few years down the line, as things mature, that can be done away with.
Okay, but I would say, see, just compare it with the Surface Act. In the Surface, there is no NCLT thing or only a small supervision by the DRT. It goes
Right.
very fine. Okay.
Mm,
Surface is purely with banks and FI. I agree with it. But in this, at least in MSME, as you said, rightly said, in many other geographies, it functions without a legal framework. It would have been better. That this is my view of it. I accept your point of view that blessings of NCLT would be better. Right. Okay.
Right. Sir, also, if we just look at, say, the June 7th circular of RBI, where the banks were, there also it has not been that successful. It did not require any court intervention, and the banks were supposed to take a call. But what I hear and see is that they are more comfortable putting a company under CRP, even when the recovery expected under CRP is lesser, because they would not, the people who are deciding, they will not be called into question at a later stage. So I think there has to be a mindset change. But when I say there has to be a mindset change, there has to be some safeguards being given to the decision makers, that their decisions are not questioned at a later stage. So also to mention that some of the provisions under the code and the regulations, like the auction process, this is yet to be tested, because the cases so far have not seen an auction. or a participation by only one case has seen a participation by another resolution applicant who has come in. And because there is no requirement of newspaper publication, you just publish it on the website. It does not get disseminated to a lot many people, and that may also create a challenge. So a few drawbacks of pre-pack are what people say is it's not that transparent process, because it's kind of a deal to hand it over to the promoter. Other thing is that there is a perceived lack of independence, because the advisor who acts from the beginning, he gets appointed as the resolution professional in most of the cases.
In fact, in Australia, this is not allowed. In Australia, in Prepack, the advisor who advises the company cannot be appointed as the RP who runs the process of Prepack. So some jurisdictions outside the country have recognized that there is a perceived independence problem as well and have sought to rectify it.
So I think we should look at pre-pack as an experimentation, and as law evolves, then there would be additional things which come in, like a pre-pack. The structure may be modified in future to see how it works. As we have seen in insolvency, a lot of ordinances came in, amendments have been happening to make it more effective. Initially, there was no requirement of Section 29A, then Section 29A has come in, and that has been a landmark change. Likewise, in pre-pack also there may be certain amendments which may alter the course and make it more effective. As of now, we do not know what amendments or what changes those could be, but we remain hopeful. P, should we end the session? If unless there are any more questions or any comments, we can end the session.
Um, yes, sir. If there is no such any other query left with the participants, so we can conclude. So let's conclude, sir. That's
Okay.
fine.
Thank you, everyone. Thank you for attending the session.
And on behalf of all
Thank you,
participants
sir.
and ICS
Thank you,
and
sir.
MP, I would like to thank you, Ashish sir and Zinat ma'am, for your insightful session on pre-pack insolvency resolution framework in India. And it was very informative and helped us gain a deeper understanding on this topic. And also, I would like to thank all our participants for joining this workshop series. We trust that this workshop series has equipped you with valuable knowledge and insights. Thank you, everyone.
Thank you.
Thank you.